everyone, and welcome to the daily newspaper analysis, which is brought to you by LawSikho. So please be reminded that today we'll be covering the important news articles and news points for yesterday, that was 3rd of August, and today, that is 4th of August. So it will be a cumulative session that we'll be taking today. Today we have an editorial for a discussion that has been taken from the Indian Express, and this is titled as Clouds Over Sunshine Law. So the Sunshine Law that we are referring to here is the RTI Act of 2005, and why there are clouds considerably on the Sunshine Law will be discussed in this article, and what are these clouds exactly. Then we have news updates and legal news for the day and yesterday. So it says that the Right to Information Act was enacted as a sunshine law with great enthusiasm back in 2005. By this, we mean to say that this was sought to bring great light to the governance of the country, wherein we were definitely looking forward to have transparency and accountability from the side of the government. So that is why it is considered to be as a sunshine law. And we all know that it was enacted back in the year 2005. Now we say that October 2022, this year, shall mark 17 years of this legislation. But definitely here, we need to ponder upon the fact that how much have we been able to achieve the goals of this exact sunshine law that we are talking about here. And have we or have we not been able to achieve what we really sought to achieve back in 2005? So the article says that, however, even after 1.5 decades, there exists deep pain points which we talk of RTI as means to bring domestic accountability. So definitely there are some bed sores that we have over here, and they need to be turned around towards the light. Otherwise, they are going to, turn very, very, dangerous for the entire social fabric. So there are some pressing issues that we need to definitely cover up, and we need to, work upon when it comes to the RTI Act of India. So it says, firstly, the huge backlogs of the second appeals. Now, if you remember back in our law schools, or even if you are studying right now as well, we generally know that there is a hierarchy that is followed when it comes to the RTI Act. So for the first, we have the PIO, that is the Public Information Officer, who is at the ground level working in this regard. Now, if at all there is any grievance against the the work of the PIO or against the information that was given by the PIO, we can move to the next step, that is the SIC, that is the State Information Commission. And if we are not satisfied with the SIC as well, we can move to the CIC, that is the Central Information Commission. So definitely there is an order of appeal or a hierarchy of appeal that is formed. But what happens is that we can definitely see that there is huge backlog of the second appeal when it comes to, that is specifically with the CIC. So secondly, we have lengthy wait time for hearings. So people have to wait a lot for their hearing chance, and that is why it actually makes them very impatient and dissolves the entire purpose of giving the right information in the right time. Thirdly, hesitancy in posting penalties and the increasing opacity in the working of commissioners. So we know that, the people, the commissioners, the PIO, or anyone who is associated for that matter, if they do not serve the right information in the stipulated time, then they are to be given penalties for that very, very purpose. But the department itself or the system itself, it is not very willing to give this, these kinds of penalties to these people. And that is why this is further increasing the opacity in the working system of the government, which is absolutely contrary to the very purpose of the RTI Act, that was to have transparency in the governance. Next, non-cooperative public information officers that we have, as we were just discussing, and constant threatening and murder of the RTI activists. If you remember, we just a few days ago were discussing about this RTI Act itself, and we were talking about that we need to provide protection to the whistleblowers who are associated with the RTI and the RTI activists as well. And we have been noticing that recently as well, and over the period of time there have been continuous murders of these whistleblowers and RTI activists. So according to the Commonwealth Human Rights Initiative, 99 activists have lost their lives, 180 have been assaulted against, and 187 threatened, which is definitely a huge number in this area. Then the vacancies of state information commissioners are also not filled, while the others continue to work without chiefs. This is, what we call as a misguided, or, where there is definitely lack of guidance when it comes to this organization, wherein there are huge numbers of vacancies, either we can see, or there are no heads or chiefs available. So definitely there is a lacuna in the department. So a particular issue is that the department secretaries who have to answer the questions Failing their duties mean that the information officers shall have to face penalties, which ultimately is causing the entire chaos in the system. So, a few commissioners going public politically is also a matter of great concern, and that is why all these, dark or gray areas need to be addressed. Now let's see what do we have for news updates. Firstly, fifth gold at the Commonwealth Games. So India's women's sports teams won the gold medal match for the first time ever with a score of 17 by 10 against South Africa. So India's men table tennis team it beat Singapore in the final to clinch the gold medal, India's fifth gold medal in the competition so far. Second, 146th anniversary of Pingali Venkayya definitely is a very, very important name. So rallies, public meetings and photo exhibitions mark the 146th birth anniversary celebrations of Pingali Venkayya, who was the designer and architect of the national flag across the state. So please remember that who was the designer of the Indian national flag? So it was Pingali Venkayya. Thirdly, India crosses 75,000 recognized startups. So India achieves a landmark milestone of over 75,000 startups recognized so far. These numbers tell the power of a vision to see innovation and drive growth, says Piyush Goyal. So latest 10,000 startups recognized, they were recognized in 156 days compared to the initial 10,000 startups in the 808 days. Fourthly, Center launches State University Research Excellence Scheme. So the government today launched the State University Research Excellence Scheme to augment the research capabilities in a structured way to create a robust research and development ecosystem in state and private universities and colleges. Fifthly, first ever gold in 4 lawn ball. So on the fifth day of the Commonwealth Games at Birmingham, Nayan Manish Saika and Pinky, Lovely Chobe and Rupa Rani Tirki script history as they beat South Africa in the women's 4 lawn bowls final to win a gold medal. This is India's first medal in this sport. They won the match by 17-10, as we were also discussing earlier. Sixth, Personal Data Protection Privacy Bill withdrawn. So after 4 years of deliberations and the government withdrew the Personal Data Protection Bill 2019, which is to be replaced with one that has a comprehensive framework and is in alignment with the contemporary digital privacy laws. Here is a very interesting question for you all. There is a particular committee upon which this Personal Data Protection Privacy Bill was based. Can you name that particular committee that talks about the privacy laws? If you know, pause this video and let me know in the comment section below. Seventhly, Suresh Patel as new Central Vigilance Commissioner. So Vigilance Commissioner Suresh N. Patel was on Wednesday appointed as the Central Vigilance Commissioner as a year after the post fell vacant. So he was sworn by the President at the Rashtrapati Bhavan. Let's see what do we have for legal updates today. Firstly, Section 482 CRPC. So it says that the interim reliefs or stay of the investigation can be granted only in the rarest of the rare cases, says the Supreme Court. So the Supreme Court reiterated that a High Court, while exercising powers under Section 482 CRPC, can grant stay of investigation or any other interim relief only in the rarest of the rare cases. This was held in the case of Siddharth Mukesh Bhandari versus State of Gujarat 2022. Secondly, right to cross-examination cannot be denied to accused for failure to deposit interim compensation under Section 143A of the Negotiable Instruments Act, says the Supreme Court. So the Supreme Court observed that the right to cross-examine the witness examined on behalf of the complainant cannot be denied to an accused for his failure to deposit interim compensation under Section 143A of the NI Act. And this was observed in the case of Noor Mohammed versus Khurram Pasha. Thirdly, Section 113B of Evidence Act casts a reverse burden on the accused to disprove prosecution case. This has been held by the Kerala High Court in the case of Ajay Kumar and another versus State of Kerala. It added that if the accused fails to rebut the same, then the court shall act on it. Fourthly, Supreme Court applies sustained provocation principle. Gravity of provocation can be assessed based on the history of abuse. So the Supreme Court observed that the purpose of Exception 1 of Section 300 IPC, that is the Indian Penal Code, the last provocation has to be considered in the light of previous provocative acts or words serious enough to cause the accused to lose his self-control. And this was held again in the case of Noor Mohammed versus Khurram Pasha. So this was all for today. We hope you liked this session. If you did, you may like it. Also, if you wish to download the PDF of today's slides, you can join our Telegram channel. The link to our channel is there in the description box below, or you can also scan this QR code that you can see on your screens right now. Thank you so much.